All right, everybody, welcome back to the Learning Out Loud podcast. I'm your host, Dustin William. I have my co-host with me, Whitestone.
I shall now attempt to show how the most important of these principia have been crystallized into the pithy form of maxims and have influenced and developed that grand system of truth known as equity jurisprudence.
The power is neutral. It's sitting in the quintessence until you invoke it. All right, welcome everybody back to the Learning Out Loud podcast. I'm your host, Dustin William, the owner and producer over at True Life Productions. You can see all of our content at truelifeproductions.com. Go visit there. I got a button up for the Learning Out Loud podcast, so you can either visit truelifeproduction.com or learningoutloudpodcast.system.io to get a hold of the second hour of the show, as well as the show notes, and a bunch of extra goodies. You can go through. You can get Mr. Tully's speech the transcript of his speech that we're going through here. So you can read along with us over at truelifeproductions.com. You can find All Aboard, my history show, where I go through the history of the orphan trains. And I just went on another podcast, the Forbidden Knowledge News podcast. So everybody can go check that out, where I broke down the hidden origins of the orphan trains. And then from there, you can go to Article 3 Articulations, where you can find the most comprehensive breakdown of the slaughterhouse cases there is on the internet. But that's enough with the business today. I'm ready to get into the show. Let's introduce our co-host, Whitestone. How's it going, man?
Oh, very, very busy, but glad to be here.
Yeah, me too. I'm excited about the show. Yeah, you've actually got a book that we're going to talk about here in just a little bit, which I am very excited to go through. But before we go there, and I don't know if I'm going to do this every show, but this is a way I like to open up the show because I am a Bible reader myself. And as we do, sometimes we record on Sundays. I always do a Bible study in the morning. And there's always something to glean out of the message of the Bible. So I wanted to share that with you guys this morning. And what I was reading, so what I'm doing is I'm going through all the stories of redemption that can be found in the Bible. And what I have come up with is there's ironically 33 stories, go figure. But I'm working my way through in a more or less chronological fashion of the stories, and I've made it to the New Testament. And today's story is, well, actually, I guess I could just put it up on screen here. Okay, so we covered John the Baptist proclaims Jesus, the Lamb of God. And you can find this story. Actually, this is available for anybody if they want to go through and study the same thing themselves. But you can find this story in the book of John in the New Testament in chapter 1. So that's what we're going to cover here real quick. And I just found a couple of interesting things. And we'll open up with just John 1 through 5. And the reason I want to open up with this just because this is one of my favorite Bible passages. Ephesians 6:10 through 20. That is my favorite Bible passage where we take on the armor of Christ to battle the wiles of the devil. Everybody should go read that passage. Ephesians 6:10 through 20. But I want to start with John 1 through 5. And it says, "In the beginning was the Word, and the Word was with God, and the Word was God. The same was in the beginning with God. All things were made by it, and without it was made nothing that was made. In it was life, and the life was the light of men. And the light shineth in the darkness, and the darkness comprehended not." So, I love this passage because not only does it say, basically what it's stating here is God spoke the earth into existence. God spoke everything that we have ever understood to exist into existence, and it states this in the creation story in Genesis, and it also states it right here. The same was in the beginning with God. All things were made by it, not by God, but by God's voice. And without it was made nothing that was made. And the reason I love this so much is because there is something that probably most people have heard of, something called cymatics. You've heard of cymatics, right, Whitestone?
Yeah, that's exactly where my mind was going with that.
I kind of figured. Yeah, I kind of figured because that is um it just the first time I had already been aware of cymatics when I read this passage. And I'm not gonna lie, it ripped my mind apart. And this passage is the passage that made it concrete that God was real because of what this passage says, and because knowing what I know about cymatics, vibration, and how things come to be, and how light works, because it's not a particle and array, or a particle and whatever science calls it. It's a wave. Light is a frequency, and it doesn't travel in a consistent manner. And I think all matter is just stationary light. So that's why this
I
passage.
agree with you. I agree. I think all matters folded light is what I think it is.
Yeah, that's a great way to put it. That's a great way to put it. But yeah, it's light folded on top of each other, and that's what creates our matter. And you can kind of see this in how crystals form. It's called a crystal lattice structure, and that's um, there's some science out there that says this, but in my opinion, crystals are the most stationary form of life. I think they grow, they meet most of the criteria of life, not all of it, but I agree. I don't know. How do you feel about that, Whitestone?
Even the Kabbalion speaks of that when it
Mm.
talks about mineral mind and mineral consciousness as being the first form of consciousness that precedes what we would call plant life.
Yeah, yeah,
So, because
yeah,
there's mineral life and mineral mind, and then mineral life or plant life and plant mind, and then animal, and then human, so on and so forth. And I agree. Crystals, they do grow, and they grow and they crack in cymatic and geometrical patterns, which means that they're manifesting the imprint of whatever life is breathing into them.
Yeah, yeah, that's a great way to put it. That is a great way to put it. Yeah, and I honestly, it's been a while since I've read the Kabbalion, but I totally forgot that they do. Yeah, they talk about the hierarchy of the forms of life, and I can't. Is it in Vibration where they talk about that? I can't remember exactly what
I don't
section it's.
remember if it's in vibration or not. Oh, I just happen to have it right here in front of me.
Nice.
But vibration, I believe. Let me see here. Yeah, we've got vibration, polarity, rhythm, causation, gender, mentalism, correspondence. I think those are the seven hermetic principles. And
Yeah,
even just in that passage, you can almost glean a lot of those from that. You've got cause and effect in there. You've got
yeah,
vibration in there.
yeah, yeah, absolutely. Yeah, I'm gonna have to read the Kabbalion again. It's been a few years. I've read it
I will
several
say it
times,
is
but
it really is a great simple tool if you just understand those seven principles and always keep them in the back of your mind whenever you're dissecting something or whenever you're learning something new. Just think about those seven principles because you really cannot condense or simplify the world farther than those seven.
no, yeah, I would agree with that
Everything
totally.
comes out of them.
Yeah, and that's how where I start my spiritual philosophy at is the Kybalion. It just does it jive with those seven principles? If it doesn't jive with that, then it's probably not real. I'm just, in my opinion, that's just kind of how I rock with it. And I know it was written by Freemasons. Well, you know what? Freemasons probably know better than anybody else. It was written by quote unquote three initiates. So,
Yeah, and who's to say, when the Kabbalion came out, uh, masonry is a much different thing than it used to be. And so,
absolutely.
you have to, I think, depending on when a book was written and who it was written by and what the status or orientation of the group at that time was, you kind of have to interpret it in that light. Just like the legal world. If you're reading a
Mm-hmm.
legal book from the late 1800s, early 1900s, it's going to give you a very different tone than something, from 2010.
Yeah, they're going to use a lot more plain language, that's for sure.
Yes.
And
And
you're
it's a lot closer to nature, in the law of
hmm
God. It's a lot less arbitrary and it's based on easily recognizable and discernible truths by every common person, I guess you could say.
Yeah, yeah, absolutely. Absolutely. Yeah, I love it. All right. So yeah, that's all I wanted to touch on in that passage, but because I we could honestly probably talk the whole 2 hours just on that. But so to keep us from doing that, I'm gonna move on to the next passages that I found very interesting. And this is John 1:17 through 19. And this is passage 17. It says, "For the law was given by Moses, but grace and truth came by Jesus Christ." And I find this very interesting because basically what they're stating is in my opinion, this is the distinction between law and equity.
Wow, look at that right
Isn't that
there.
crazy?
And wow.
Yeah, yeah. This just that jumped right out at me this morning. I was like,
Well, I mean
no way.
I mean, didn't he have they were written on tablets of stone?
That's exactly what they're talking about. Yep, yep.
Yeah, because I mean, it's in stone, it's written. If it
Right.
doesn't fit it, oh well.
Right, it's the written law, but grace and truth come by Jesus Christ. And as we'll go through, we get further in the speech, Tully actually kind of, he doesn't exactly talk about John 1, but he talks about this concept. And yeah, it's very interesting. Yeah, they even label the stark distinction. And this is from the 1560 Geneva Bible right here. So all the way
Wow.
from the beginning, they've recognized the difference between law and equity. And then so we go on from there. This is passages 18 and 19. No man hath seen God at any time, the only begotten Son, which is in the uh, bosom of the Father. He hath declared him, his Father declared him. Then, and then this goes on to a different uh, paragraph, but and this is the record of John. So, and this is the first time that's stated in the passage, but this is the book of John is the record of John, and they so the Father declared, and then John is recording this, and that's the first time they state it. So that's one record. Then we go to John 1:32 to 33. So I, John, bear record, saying, I saw the Spirit come down from heaven like a dove and aboded in him. So he's saying he is putting on the record that he witnessed the divinity of Christ. And that's the second time he put it on the record. And then we go to John 1:34. And I saw and bear record to this is the Son of God. So, what do we know about things working in three, Whitestone?
Yep.
That's that's the entire concept of. Well, it's not the
Trinity.
entire concept, but it is one of the biggest things in equity. Is that these judges are going to test you three times
Yep.
on everything, and here John is explicitly stating that he put on the record three times that Jesus is the Son of God. So, um, it just gets deeper and deeper. Man, the more I read this book, the more I love it, the more I glean from it. So I encourage everybody to get you a 1560 Geneva Bible or a King James, whatever, man. Just start reading the Bible and start reading it with purpose. So
The older the better.
yeah, absolutely, absolutely. And I just picked up a 1560 Geneva Bible from my local bookstore for about $80, I think it was.
No
Uh,
kidding.
yep, yep. It was the
God,
only
make me
copy they
jealous.
had. It was the only copy they had. And I
Well, get them while you can because most of these smaller bookstores are becoming a thing of the past. Now we've got corporate secondhand stores, and that's about it.
well, it was funny. It was actually at a bigger bookstore because we don't have like a small local bookstore except we have a used bookstore which I like to go to. But
Is
this
it
was
the brand, the corporate brand that everybody's pretty much familiar with? It's got chains everywhere.
what is it, Half Price Books or whatever?
Yeah.
No, no, actually it's not. We don't have a Half Price Books here. It's a BAM Books a Million.
Oh, wow.
Yeah, yeah.
Half Price Books probably has about half of my net worth. So
Nice. Yeah, you got a good book collection over there. That's for sure.
yeah, I think I'm almost to 1800. So 2000's coming up.
Nice, nice. Have you put
Yeah.
them in a trust yet?
Actually, yeah. So I created my own. They're actually property inside of my own private trust. So
Okay, cool.
I created my own stamp. I just went on and created a custom stamp. It's basically a private library. It says property of the name of the trust, and then it's got the private trust number in there. And so basically, it's a wet ink stamp. I stamp it in my pad. I open my book, stamp it on the inside, give it its own special um, number, basically. So it's the
Number.
trust
Yeah.
number dash, however, whatever book it is
Whatever
that we
book it is.
run.
Yeah.
The first book that I put into my trust was Ray Bradbury's Fahrenheit 451. That's the first one that
Nah,
went in
that's a
there.
great one to put in there first.
Yeah.
That's a yeah,
So,
good one. Nice, nice. Yeah,
but
that's awesome, man. Yeah, the reason I ask is because I'm getting ready to do the same thing with my book, so I was wondering if you had done the same thing.
yeah, I still need to technically, um,
An
write up a
adventure.
deed for all of those. But other than
Oh,
that,
okay.
yeah,
Yeah. Yeah, yeah, that's cool. And that's actually that's actually how I'm going to teach my son about trust because he's been getting into really into books lately. So,
good.
I'm going to put all of my books into trust and make him the beneficiary of it. And then I'm going to have him create his own trust and he's going to be the trustee of his own books until he
Okay.
has children. Yeah. Yeah.
Wow,
So,
great.
yeah, I thought that'd be a great way to just teach him how trusts work. So he has the concept in his mind. Um,
No, that's very good.
Yeah, yeah. So, all right, man. Yeah, so that's all I got out of the Bible today, but I thought that was very interesting. Um, Putting stuff on the record 3 times. It's like it's all connected, man. Like as we're gonna say on the show a million times, and that's why we called it the Learning Out Loud podcast because we don't want to we don't want to, spending the first 10 shows talking about equity, but we didn't want to box ourselves into that because equity is connected to everything, and everything is connected to
Yes.
equity, as we just read here. So.
Yeah, I would
Um,
say equity is the way that you get treated depending on how you act. I keep thinking about how to sum it up in one thing, and really equity is you get what you deserve based on how you act.
Yeah,
And
I
I
mean
mean that goes into so much life.
it really is just the golden rule, man.
It is. It
You're gonna
absolutely
get
is.
treated exactly how you treat people. So,
Yep. And I think, the golden rule is the tree, and all of the different maxims and all of the different doctrines are just branches of that tree. But really, overall, when you stand back and look at it, it is the golden rule overall.
yeah, yeah, absolutely,
So,
absolutely. All right, man. So yeah, that's all I got out of the Bible today. So what we're gonna do now is actually, you went where'd you go upstate or something and went to a
okay, yeah.
bookstore.
So funny how life throws things at you. So I'm up in the Pacific Northwest out in Idaho, and not a lot of people know this, but Idaho City, which was the original capital of Idaho before Boise, Idaho City had the largest gold rush, bigger than California. And at the height of its population, Idaho City had more people than Portland back during the Civil War, just to give
Mm.
you an idea of how populated it was, because there's so much gold up here in the mountains. Don't come up here.
Now it's the least densely populated fucking state in the union, isn't it?
Yeah, don't come here.
Yeah, yeah, don't come
Stop
here. Stay
coming
far
here.
away.
I'm sorry,
Stay far
everybody.
away.
Please stop coming here. There's so
Uh,
many people here.
That's how I feel about Michigan, man. Well, I was one of those people that moved to Michigan, so I can't really bitch.
Yeah, I mean I was here in the early 90s, and it's just anyway, different
Yeah.
conversation.
Yeah,
But so
yeah.
I went up to Idaho City. I was like, I'm gonna go spend a day up there. I'm gonna try to find me some gold, and ended up walking to an old antique store,
And you
and in the
did.
very
You found
back
some gold.
I did find some gold.
Yeah.
So what I'm gonna do is I'm actually gonna turn my camera on, and I'm sorry for the Cloverfield-esque. I don't know. Are you able to screen share what I'm doing here?
Hold on. Let me switch the shares real quick. Um, Actually, you might need to do it from your end. Can you see the button right there at the bottom? It says share.
Boom, boom, boom. Share. Yes, for everybody who doesn't know, I'm inept when
Yeah.
it comes
He's
to
pretty
this
much a
thing.
Luddite, so
Yeah, I really am. Let's see.
should be right at the bottom.
I'm just gonna
Yep.
try this.
Search
All right,
share.
we working there?
Um, we see Zoom. We don't see your camera though.
Okay, let me crap.
I guess we should have run through this before. I didn't think about it.
Yeah, all right. So I think stop share. Okay.
Okay, now we got it worked out. So we're doing this just so you can because we don't I don't have a copy of this. There's not even a digital copy of this book available online. So just so you guys have a
No.
reference, we're putting this on screen for you. So
Yes. So this book, I have tried my darndest on the internet to the best of my ability to even find this book. And the only link that I could find to this book was an expired eBay sale from about 6 months ago from one of these copies.
oh
So
dang.
this
It's
book
probably the one
here,
you got.
I don't know. I mean, I found it in an antique store and it was on the bottom shelf, buried in the back, probably hadn't been seen in years. It was $10. So,
Nice. Oh, that's a
um,
score, bro.
oh,
Dang.
just wait until you get into this book. So this book is published by a group called the American Institute. You can see it's a small leather-bound book, and it's a series in which this one here is number one, produced by the American Institute. And the name of the series is Law, Banking, and Business. And this series covers commercial law and legal forms. I have not found volumes two, three, four. They may as well be ghosts. The only thing I could find on the internet was another one of these, volume one. So, what's interesting, and the reason I wanted to share this book is because it was produced or it was written in 1918. So, we're looking at about what, 108 years ago. This is before 1933. This is when equity was still in play. And this book actually does state openly equity. So, the name of the
Hmm.
book is Law, Banking, and Business.
There's
So,
no
this
comma
here,
between law and banking. I just want to point
there's
that
no
out.
comma here. So law banking, it's referring to a specific type of banking and business, commercial law and legal forms, in which this is volume one. So I'm not going to read the foreword, but basically, purpose of this text is to present clearly the underlying principles of each subject treated in a reliable and practical way. There are thousands. So basically, it's talking about working professionals, those that are in the career. But this is what I wanted to look at. Besides this, there are thousands of older men whose early education has been neglected and who are now at the head of a family and find themselves greatly handicapped on account of their limited knowledge of
Mm.
business. It is for such that this business treatise has been largely prepared. So basically, it's written for somebody who neglected their education and doesn't know anything, or
It's
those who are
written for
actively.
rich kids that fucked up and didn't pay attention in
Yes.
school.
So, what I wanted to cover is why one number one, why are we sharing this book? Is because all of these subdivisions in here, whether it's contracts, promissory notes, employer employee, guarantee, affidavits, agency, power of attorney, apprenticeship, arbitration, bailment, and bankruptcy, how bonds work, different types of bonds, what a broker is, the definition of different types of partnerships, how to have an article of co-partnerships,
Mm.
debts and collections, forms of summons, cost of collection by law. This one right here is really important. Deeds, different types
Yeah.
of deeds. And the way that, or this one's
Ooh,
huge,
mortgages.
mortgages.
Yeah.
Um, and
Nice.
then it also in some of these sections will list all 50 states and give a brief, one paragraph or two or three sentences on how each one of these subdivisions are viewed in each state.
I like
Also,
that it's only
landlords
about
and
250 pages too. That means they get right to the point and all this shit.
no, and there's no fat in this book.
Yeah, I
It's
love that.
all 100% data. And what I wanted to go to really quick, well, I just wanted to point out. So, like in contracts, for example, basically, a contract is agreement to do a certain thing for a certain consideration with a time either stated or implied. And then it goes into the necessaries, like all contracts need to be in writing.
Mm.
Contract contrary to public policy is basically, let's see. Oh, yeah. It's talking about how a contract can be void if it's contrary to public policy, who may make um, contracts, minors, insane persons, idiots, persons
Mm.
deprived of their reason by alcoholic or drug addictions, persons under guardianship, or persons
Ah.
who have been lawfully declared to be spendthrifts are not competent to enter into
Oh,
contracts.
spendthrifts, huh?
So I looked up
Wow.
spendthrift, and a spendthrift is actually somebody who either by alcohol or drug addiction or incompetency basically has to be taken care of.
That which is from what I understand, that's kind of how a lot of our commerce works today in these contracts that we're in. Is a lot of it
Yes.
is spendthrift trust.
And what's
Interesting.
interesting is, there's no, like I said, there's no fat in this language because it tells you right out, corporations can enter into contracts, but they can't do anything beyond their charters. The law,
Mhm.
this is interesting. The law is generous in granting corporate powers, but it is jealous in seeing that in no case shall they be exceeded nor their limitations ignored. So basically, if you are a corporation, the state is God.
Huh.
So
Yeah,
things a
yeah.
contract should include consideration. A contract without consideration, if not under seal, so maybe not notarized or not
Hmm.
witnessed, is void at the option of the party against whom it is sought to be enforced.
Hmm.
So when you are sent something that says you must be here, whether, by some municipal agency, a corporation, whoever else, if it is not under seal, it is an invitation to contract only because there is no consideration and it's void at the option of the party against whom it is sought to be enforced.
Hmm. Now you just have
Okay.
to learn how to express that.
Seal. So I'm just going to blaze through some of these real quick, some of the high points.
Yeah.
A seal after the signature of a party to a contract implies a consideration, whether a
Hmm.
consideration be specified in the body of contract or not. In former times, a seal was used on documents as the written signature is now used. So
Hmm.
basically a
Hmm.
seal and a signature is almost the same thing.
Yeah.
Uh,
Interesting.
and it just goes into wet ink signatures. It goes into formalities. It also goes into where it was. Actually, I don't. It might not be on this page, but it talks about restricted signatures,
Okay. Oh,
contract.
nice. Yeah, that's
Yeah,
huge.
it really so. And what's interesting is it goes through all the required points that need to be in a contract, and then what it does is it gives you a couple different um, options, different forms. Like,
Oh, a couple of different examples, huh?
yeah, it gives you examples and basically templates, different types
Oh,
of agreements,
nice. I
different types of
love, yeah, I
templates.
love it when they do that. That's great.
Contract to build, contract for hiring a farmhand, contract with a clerk or workman, contract to cultivate land on shares.
Nice.
Look at this.
Yeah, that's cool. Points on a subscription to a church. Huh.
So it talks about subscription. Everybody wants subscribers, but nobody really understands what that actually
Yeah.
means. Contracts by letter. So then we get into things like promissory notes, which is
Oh, yeah.
basically the driver of mortgages.
Yep.
So it tells you about what a negotiable note is, different types of notes, parties to a note, how to negotiate notes, the negotiability of notes, transfer after maturity, coffee stains, uh, holders in good faith, absence of consideration in case of fraud, theft, or robbery. Let's see, a note executed under duress.
Uh.
I'm trying to get to another part here. Uncompleted
Yeah, you're
notes.
cool. Yeah, no, yeah, I'm fascinated by this
As
stuff.
otherwise, I'd read this entire book.
Right. Note
Yeah,
made
so
payable at a
if you really
bank.
want to understand promissory notes, the language in here is so very simple. Just keep a copy of Bouvier's Law Dictionary with you and read this. I don't know. I may do an audiobook of this.
Okay.
I
Nice.
may, just because it is just such an easy and good read.
It wouldn't take us
But
long. Yeah, we could.
different forms of notes. You can non-negotiable note, negotiable without endorsement, negotiable by endorsement, payable at
Oh,
bank, all
endorsements,
these
huh?
different. And what's
Yeah.
great about these forms is it tells you the language. And if you look at the way they write the numbers on money, $100.
That, yeah. Yep. There's a
And in
big
here,
difference between writing it out and the numbers. There's a
and
huge
that's in here
difference.
too, because in some of these forms, they'll have the dollar amounts written either in numbers or the actually spelled out. So they're referring to two different species.
Mm-hmm. Yep.
Um, Judgment notes, trying to get. So look at
Endorsement
this.
notes.
Forms of endorsements. It basically is showing
Nice,
you like
bro.
on the back of a check. Special endorsement. You just actually I'm going to do this here.
Yeah.
Special endorsement. Just John Smith.
Endorsement
Another
in
special
blank.
endorsement.
That's what everybody's doing is endorsement in blank.
Yep.
that is where we're getting in all this trouble because we're signing things in the wrong way.
Because and it actually talks about not having a restricted signature, and I think it does on this. Sorry if I'm making everyone dizzy. Um, but you can do a restrictive endorsement where it's
Yeah.
paid to Charles Sheldon only. So if someone writes you a check, you can turn around and do an assignment and restrict that assignment. So you go to the bank and you basically I don't know how would that work.
Well, I mean, that would be the same thing as putting on special deposit for private credit, right? We're
Yeah, but
assigning
it's
where the
not for
money
your
goes.
private credit. It's for Charles Sheldon or
Well, right, you
whoever.
would be assigning it to somebody else's private
In
credit,
the
but same
the
concept,
wording
yeah.
there. A conditional endorsement. So this is a check. You could put this on a check. Pay to James Jones or order unless you receive notice from me not to pay before maturity.
Huh.
Also, pay to John Jay or order without
Without
recourse.
recourse.
So it does
Qualified
talk about
endorsement.
without recourse here in this book. I'm just trying to remember. And it also goes into forms of orders, which is really interesting because we see orders both at law. You see them at the retail counter. A check is basically an order. What's
Hmm.
really what's really crucial to understand about this book is that it goes through all of the different engines and machinery that are running this entire system, which is mortgages and promissory notes and
Hmm.
waiver and consent, acting as agency, principal debtor relationships, employee employer relationships. These are the engines that are basically running this game that we are all in. And so this is a very, very basic overview of all the different types of commercial or legal paper or whatever concepts that you're going to be running into, how to interpret them, and then also, different forms of what do you call them? Templates that you can use.
Hmm.
So that's promissory notes, employer employee agreement, which is interesting in here because it explicitly states that if in the working conditions and in the working contract between you and an employer, or sorry, between employee and employer, if the length of employment is not specified, it's considered to be week to week or check to check.
Oh, interesting. Huh.
Let me see here. See if I can find it. I just remember. mm, Talk about giving notice. No. Okay. Anyway, so I'm just going to move on from that. Talks about compensation. And then it's really interesting because it talks about compensation for death or for injury, and then it goes through every single state as it was in 1918 and talks about what the state or the corporation would have to pay out to a widow or to
Hmm.
dependents, and everything else. I just thought they went into great detail for every single state about disability and everything like that relating to um, your employment.
Interesting. Yeah.
This one was really interesting. Section 4, guarantee, affidavits, and agency. Even if,
Hmm.
if nobody read anything other than this chapter here, understanding this one, agency and affidavits, is crucial.
Hmm. Yeah, absolutely. Yeah, affidavits are the most
Let's
powerful
see.
thing. That's the most powerful piece of paper you can
Yeah, I'm
have.
going to go to. So, an affidavit is a statement made under oath or affirmation before an authorized official and signed by the person making it. When are they used? In judicial proceedings, except for trials of causes, affidavits are the usual means of presenting evidence to the court and are most frequently used to support or oppose numerous applications for orders known as motions. No particular form is prescribed by law, but the affidavit must specify the state and county in which it is made so as to show that the officer who administered the oath had authority to do so.
Hmm.
Where the matter involved is between two citizens or two or more states, the officer must be certified by the clerk, blah, 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 blah. Talks about a jurat. So when you write up an affidavit, you can either get an acknowledgement at the bottom, signed by a notary, or a jurat. I believe an acknowledgement is the notary is affirming that you are signing in the capacity that you say you are signing in. And a jurat, not a giraffe, a jurat, is basically you're certifying that everything you're stating there is under oath. because I've done both. I've tried both of them, and when I put the language of a jurat in there, the notary reads it, sees that it's different than an acknowledgement, and then says to me, "Do you solemnly swear that everything pertain here in this
Really
affidavit, best of your knowledge?" And I swear, and I say, "Yes, I do." So right then and there, you're swearing before the court.
interesting. So
And
you
then it
really
gives
want
some
to do a
general
jurat.
forms
You
of
don't want to do
affidavits.
a.
A couple different examples there. Agency. An agent in law is a person authorized to act for another, called the principal. The relation between them being known as agency. Agency is one of the most common and necessary relations of life. Nearly
Mm-hmm.
everyone acts every day as the agent of someone else. Thus, every clerk in a store is the agent of the proprietor. Almost all the business of brokers, commission merchants, lawyers, auctioneers, etc., is some sort of agency. Corporations act wholly by means of agents, these their officers, clerks, or etc.
Yeah, they
Anyone
do.
who is
That's
competent
just
to
a
do business
fact.
for himself may act as principal and appoint an agent to transact for him. And we've got a couple different types of agents here: a general agent, a special agent, or how they are appointed. This is really important here. How appointed? An agent's authority may be given orally or by writing. No particular firm of words is necessary. In important matters, the agent is often appointed by a written instrument which is called a power of attorney.
Mm.
When thus authorized under seal and said instrument duly acknowledged and recorded, an agent can sign deeds or other conveyances of real estate or sealed instruments. Talking
Mm.
about the extent of authority, whoever the principal is can extend either limited, general, or as other kinds of specified authority to their agents. Talking, and then it goes into liability and wrongful acts of agents and how the principal is going to be responsible for that. Compensation, responsibilities to third parties, revocation, accounting,
Sub-agents,
um,
huh? I never even heard
how to
of that.
revoke an agency. And then it also gives a couple general forms and templates for power of attorney or to take charge and carry on business. Power to vote as a proxy. And then we've got letter of revocation here.
Oh,
So,
nice. Nice.
yeah, it's just really interesting how simple this language is in talking about. Sorry, we got trying to get the flight here. Um, Apprenticeship and arbitration. I'm not going to go into that one. This one here, assignments, bailments, and bankruptcy. So again, everything that we live in is being, or this whole system that we live in is being run by, I call each of these, like machines inside the engine. So an assignment is, part of the machine.
Yeah.
Bailments are mortgages, chattels, promissory notes, waiver and consent, agency. They're all just different, working modules or working components inside the machine. So an
Mm-hmm.
assignment is the transfer of a debt, obligation, bond, wages, or any kind of property, personal or real, or any actual interest therein. It also signifies the written instrument by which the transfer is effected. Let's see. What is assignable? What is not assignable? Different templates here where you can assign your beneficial or equitable or legal interest to somebody else
Hmm.
for consideration. It also says that this should be acknowledged and recorded the same place as a mortgage, like if you do an assignment.
Mm-hmm.
Oh, what's interesting, Dustin, is have you gotten your double authenticated certificate of live birth back from the Department of State?
Finally, yes, I finally got it back. Yep. Yep. Can you hear me? Oh, shoot. No, you can't hear me, can you? Why? Can you hear me?
Oh man, I'm sorry. I did not realize my freaking speaker went out.
Oh,
How long has that been out?
a minute, but you've been going, so it's not it's not
Okay,
too
yeah,
bad.
sorry about that. I
Yeah.
that speaker button's on its way out, and I did not realize that it had turned off.
Yeah,
My
no
bad.
worries. But yeah, I just got my double authentication back in the mail finally.
Okay, so do you recognize this language here?
No, all men buy these present.
So if you look at
Yeah.
the double authenticated certificate of live birth, when you get it back from the State Department,
I
it's
remember
got
seeing
that
something like that. Yeah.
it's got that yellow whatever the yellow piece of paper is that they sign and seal and
Yeah, I've
affix
got
it
it
to the states, they use that exact language. Know all men by these presents.
right here. Huh, I don't see it on mine actually. No omen by the full faith and credit.
Where
Testimony.
hold on.
Yeah, I don't see it on the. I actually don't see it on mine.
Really?
Yeah.
Um oh, you know what? Sorry, it's the language is slightly different. It's to all whom these presents shall come, greetings.
Oh, right. Yeah. Okay. Okay. Yeah. Now I got you. I got you. Yeah. I
Right.
was.
But
Yeah. Yeah.
still,
Yeah.
it's still written in that same language. Know all
Right.
men by these presents, which basically it's declaratory.
To okay. So yeah, it's basically yeah. So that's in a past tense. That's the one on the birth on the authentication is more in a future tense.
Correct.
Okay.
So it also goes into bail, what the definition of bail is. Bail is surety given for another's appearance in court. It is required in criminal cases. The term bail is also applied to the sureties themselves and to the amount in which they bind themselves for the appearance of their principal.
They bind themselves, not
Yeah,
somebody
so it's
bound them.
voluntary.
They bind themselves. Yes.
So when you go into a courtroom and you volunteer to be the all caps name, you are binding yourselves to the principal, which is the all caps name, because you are surety for another's appearance, which is the debtor or the principal, the all caps name, whatever you want to call it.
Yeah.
Okay. And then sorry, I'm just trying to get this focus here.
Yeah, no worries.
Form of bail bonds. And then bailment is different. Bailment is a delivery of goods or money by one person to another in trust for some special purpose upon a contract expressed or implied that the trust shall
Oh,
be faithfully executed.
interesting. I didn't know that. But Story's got a whole book on bailments.
Yeah, so bailment is very tied up with trust and sureties.
I'm gonna have to get more into that. I'm gonna have to start poking in that book a little bit. I bet there's some
Yeah,
good shit in
it's
there.
almost like, hey,
Yeah.
I'm
Okay.
bailing. Let's see,
Personal.
responsibility bearings. The rules governing the law of bailments are a bailee who derives no benefit from his undertaking is responsible only for gross neglect, or in other words, for violation of good faith. So it's interesting because it covers gross neglect, um, three or four different types of neglect, depending on who's getting a benefit and depending on the capacity, so on and so forth.
Oh, interesting.
But it goes into a couple definitions under bailment, which is a borrower for use, a pawnee, a depositary,
Ah.
a carrier, a private carrier, a workman for hire, innkeepers, warehousemen.
So
By
it's
the
cl
way, this
almost like an employee, but not quite.
almost.
Yeah. Okay.
What's interesting is this book has made several references to subsequent volumes, like volumes 2 or 3, which talks about how warehousing works. I spent many years in that industry, and warehousing is I mean that's where supposedly banking got started, where people would store things in a warehouse and they were given a receipt for what was stored there, and people started circulating those warehouse receipts as currency.
Oh, kind of like as bills of exchange they
Yeah,
are.
bills of
Yeah.
exchange,
Yeah.
basically.
Okay.
And
Interesting.
so I would love to find volumes 2, 3, or however many they are, because this is only covering commercial law
Hmm.
and legal forms.
At least you got
So,
the good volume. I bet that's the best one. But
oh yeah.
yeah, yeah. If
So
anybody
anything
out there is searching can find any of these, let us know. We would love to get our hands on the rest of this series.
insolvency and bankruptcy are not the same.
That's
So
interesting.
I was reading this morning, um, and trying to find what was so it goes deep into bankruptcy, what a bankrupt is, an act of bankruptcy. Where was it that talked about natural persons? Let me see here.
Hmm.
Voluntary bankruptcy. Any person who owes debts, except a corporation,
Huh.
shall be entitled to the benefit of this act as a voluntary bankrupt.
Interesting.
Involuntary bankrupts, any natural person except a wage earner or a person engaged chiefly in farming or the tillage of the soil, the land,
Whoa.
so basically any natural person,
Any
any
unincorporated company.
any
Okay.
unincorporated company, and any corporation engaged principally in manufacturing, trading, printing, publishing, or mercantile pursuits, owing debts to the amount of $1,000 or over, may be adjudged an involuntary bankrupt upon default or an impartial trial, and shall be subject to the provisions entitled, and shall be subject to the provisions and entitled to the benefits of this act. And it was referring to the National Bankruptcy Law of 1898.
Huh.
And then it says private bankers, but not national banks or banks incorporated under state or territorial laws, may be adjudged involuntary bankrupts. So it's
Oh.
interesting. Private bankers may be adjudged involuntary bankrupts. Okay, well, what is
Yeah, what's a
a
private banker?
what's an involuntary bankrupt? An involuntary bankrupt is any natural person,
Oh. Yeah,
except
yeah,
a,
yeah.
so I think when they say here, except a wage earner or a person engaged in farming or tillage of the soil, I think they're talking about the natural man.
Yeah, I mean, they would have to be, yeah. Except a wait. That is interesting. We would, yeah, I think we'd really have to
Yeah,
dig into that to
there's some of the
really
ways
understand
this
what they're
book,
saying there. But
yeah, some of the ways that this book uses language, it's really telling you what is actually going on, maybe without realizing that's what it's doing.
well, and I mean, we've talked about it before. I think people from this time area kind of saw what was coming, and that's why there was this explosion of literature right around this time
Yes,
where they were just
absolutely,
telling the truth.
absolutely. So that was bankruptcy. Section 7 is bonds, and it goes into the different types of bonds. Well, you'll check this out. Well, hold on. A bond is an instrument in writing whereby one person binds himself or several persons bind themselves to another or others to pay a sum of money, to abide by an award, or to do some lawful act, or not to do some particular thing or thing specified in the condition of the bond.
Hmm.
Different kinds of bonds. If there's no stipulation in the bond, oh, sorry, let's skip this. Names of parties. The person who gives the bond and so binds himself is called the obligor. The
Hmm.
person receiving the bond is called the obligee.
Hmm.
So if there's no stipulation in the bond that the obligor shall suffer any penalty in case of non-performance, the bond is called a simple one. But there generally is a condition added that if the obligor does some particular act, the obligation shall be void, or
Hmm.
else shall remain in full force as payment of rent, performance of covenant in a deed, or repayment of a principal sum of money borrowed of the obligee with interest.
Interesting.
A seal is required on bonds. Bonds at common law must be under seal. The seal making proof of consideration unnecessary because it imports a consideration.
And just one distinction that needs to be made here is when he says common law, that's a different common law. He was talking about a different common law then than is today because he wasn't even aware that common law was about to get thrown out of the courts. So he's
Right.
talking about like the real actual common law, not the shit we deal with today.
Yeah, 20 years hence from this book, with 1938 is when we lost it.
Yeah, exactly, exactly.
So
So,
what's interesting, and when we read this, bonds at law must be under seal. The seal making proof of consideration unnecessary. So there doesn't need to be valuable consideration on it because it imports a a consideration.
mm. So
And what we
basically, it's an
remember,
imputing an intention, kind of like we're going
what
to
we
talk about.
remember about seals is it says that seals can be used in place of a signature at that time. And if your signature is on a piece of paper with a monetary amount, that in itself is a note, isn't it? And so
Yeah, I
really
think so. Yeah.
by putting your signature on it, you're almost creating that credit, which is almost the consideration in itself.
Huh. Yeah.
I don't know. That's just how I
Interesting.
was
Yeah.
thinking about it. I'm
Well,
not
I
sure if
mean,
that's
but
actually,
yeah, that's interesting because I bet that's how they get a lot away with this shit without consideration.
yeah, all they
It's
need is
because
a
we're
signature
creating the
or
seal.
a
Yeah.
name or something. So anyway, that's bonds. I have not gone into a commission merchant yet,
Hmm.
but I am under the assumption and the belief that much of the Article 1 nonsense that goes on at the municipal levels are done under the what would you call it? The auspices of commission merchants, because
Huh.
a lot of these municipalities have dozens and dozens and dozens of commissions under their belt, and they're all merchants.
Interesting.
So they
Yeah,
have a
I mean, yeah,
responsibility, they have duties, they have authority, they have responsibility to the principal.
which is the commander in chief.
Yep.
Hmm.
And what's interesting is the commission merchant templates. There's more all caps language, and the other ones don't have
Oh,
it.
yeah, that's very interesting. Yeah.
So,
Huh.
a partnership. So it talks about different types of partnerships, um, how to enforce them, dissolutions of partnerships, liabilities, articles of co-partnership. Kind of gives some examples there. Debts and collections. I
Hmm.
mean, this is a huge one here. Look at it right here. To avoid debts, do a strictly cash business. Better small profits and quick sales than large profits and long credits.
That is wow. Yeah, I mean,
Debts
that's
and
crazy.
collections.
You will not find that in any financial book today.
Nope. Look, pay as you go or a strictly cash business is the best and safest method of doing business. But certain conditions or customs in trade make this sometimes impractical or impossible, and credit must be given. Under this
Mm.
method, dishonest, careless, or unfortunate people contract debts, then refuse, neglect, or are unable to pay them, and collections, peaceable or forced, become a necessity. This is the most unpleasant feature of any business.
Yeah, you got that right for
And
sure.
it talks about collecting a debt, and it goes into letters requesting payment, first steps in making collection. So it's telling you how you can
You can
enforce
collect your debts. Yeah.
your own debts.
Yeah,
Um,
and you can reverse engineer all this shit for when they're trying to collect a debt from you.
Absolutely. And what's great is the language in here. It's very succinct, it's very to the point. It leaves no room for alternative constructions. It's
Nice. This is a yeah, this is
look
a
at
gem right here.
I
Form
could
of some
you could
nice.
who knows, maybe I could so I.
I mean, yeah, why not?
Either party in a trial before a justice of the peace may demand a jury, and the justice is bound to grant the demand upon the deposit with him of the jury fees by the party making the demand.
Huh. Oh, attachment.
Oh, yeah, let's talk about attachment.
Yeah,
While the
for sure.
cause for which an attachment writ will issue vary somewhat in the different states, the following grounds are almost universal. Where the debtor is a non resident or a foreign corporation,
Hey.
where the debtor is about to remove from the state, where the debtor conceals himself so that process cannot be served upon him, where the debtor has removed or is about to remove his effects from the state to the injury of creditors, where the debtor has fraudulently conveyed, concealed, or disposed of his property so as to hinder and delay creditors, or is about to do so, where the debt was fraudulently contracted and the statement constituting the fraud reduced to writing. So
Hmm.
those are the conditions under which attachment would follow.
Which sounds familiar. I
If you've
mean,
got creditors coming after you for something and you're doing a tiptoe dance and you're conveying your property and hiding it, basically they can basically come in under attachment and attach all your property for the benefit of the creditor.
which is what we live under today. Basically, everything we deal with is an
Oh
attachment.
yeah. And so really it goes, and look at this.
Attaching the body.
That's what
Hey.
we call. So, what was our very first equity maxim? Equity acts in
Yep.
personam.
Yep.
That's what that is.
Attaching the
If
body. Yep.
under an attachment, the officer returns no property found, but the plaintiff is convinced that the defendant has property concealed with the intention of defrauding him and believes he is in danger of losing his claim unless the debtor is held to bail, several states empower the justice to issue a capias for the arrest of the debtor. A capias is issued usually only as a last resort when it appears that the claim can only be collected by arresting the defendant.
Hmm.
Persons who cannot be arrested, it talks about the Constitution, basically prohibits members of Congress and electors while on duty, except for treason, felony, and breach of peace. And
Oh,
then
isn't
basically
that convenient?
militia, attorneys, counselors at law, judges, sheriffs, and all other officers of the several courts. Also, basically, if they're on their way to court, they cannot be. cannot be arrested. So I just thought that was interesting. Let's talk about garnishments a little bit here. Suing the garnishee, right to appeal. One thing I wanted to actually point out here, where is it? Yeah, so basically, with the intention of defrauding him and believes he is in danger of losing his claim unless the debtor is held to bail. And so I went back to the definition of bail,
Oh
and that's
yeah.
basically where the surety is bound to the debtor. And so they're basically saying that we have to arrest the surety for the debtor. That's what that means.
Right, right.
The debtor is
Yeah.
held to bail. That means that the surety is going to be compelled to serve as the debtor. And that's important because
You're the
right here,
surety.
I recently demanded of a municipal agent that I was required to serve as surety for a debtor and that I had to be held to bail for it. Otherwise, I'd be discharged, and I never heard anything back.
Yeah.
So it's because I never volunteered, I never consented, and I had proved 10 ways from Sunday that I was not the surety. And when push came to shove, I issued a notice to disclaim and said, I demand a declaration, a sworn affirmation or an affidavit or a enunciate or a rebutment of my claims, or basically verified proof and prima facie evidence that I am required to serve as surety for the debtor.
Hmm.
So right here, that's one of the ways you can defeat in personam is by demanding that they prove that you are to be held to bail for the debtor.
And what's that? That's been about 3 weeks now. You haven't heard anything from him, right?
No, I have not heard anything. I
No,
do I
nice.
do have it on good authority that my name is still on the list, but they are quiet and not talking to me. So, because I know somebody down at the prosecutor's office who told me that they saw my name as of like 2 days ago, still scheduled for jury duty, but
They're
they
just
won't
not.
talk to me. So,
They just won't talk about it.
yeah, they're just going to be like, we're just going to push that through the system and we're just not going to talk about it.
Yeah, we're just gonna forget that happened.
So, but by the way, there are 4 or 5 people in the valley that have my exact same name. And when I was asked about it, I said, oh, it must have been one of the other ones.
Oh yeah,
Um,
there you go. Yeah, because yeah, so yeah, I mean,
Prove
really,
it's
with all
me.
your, but yeah, prove it's
Prove
you.
it's
Yeah,
me.
absolutely.
Uh, yeah. So anyway, that's debts and collections. There, it really goes into it. This one, very important. Deeds. A deed is an instrument in writing whereby real estate or some interest therein is conveyed. This right here is probably the most important paragraph.
Hmm.
Um, a deed, when delivered, is good as between the parties, but in order to protect the purchaser's rights, it must be filed at the office of the county recorder.
Hmm.
If a deed be not recorded, and the seller executes another deed, and this other deed is recorded, the first buyer loses his claim to the property and has no
Absolutely.
recourse other than a suit against the seller for damages. Right here, recording a deed is vitally essential to good title.
Gotta have that good title. Nice.
Yep.
Yeah. Yep. Okay. Interesting.
So, and it goes into different types of deeds. Oh, no, sorry, the requirements for deeds. So it's got to have competent parties, consideration, deed must be reduced to writing, and it must be duly executed and delivered. It's got to have consideration
Yep.
on which the consideration on which the deed is based may be either good, as for love and affection, or valuable, as for money or other property.
Oh, I've never heard of consideration being good. I've never
Yeah,
heard of good consider. That's
that's got to be a
interesting.
good. That's got to be a good faith
It
thing, right?
has to be. Yeah, it's got to be a good faith thing.
Got to
That
be a
would
good
make
faith
sense.
or valuable as for money or other property. It's
Huh.
almost like they're saying love is binding, and under good faith, you're bound to it as if it was actual valuable money.
And well, that goes into trust a lot with like when you get into like inheritances and stuff like that. It's like it
Yeah,
goes into like what was the intention of the party and like was it a
right.
good faith? Yeah. So
And
basically,
here's
yeah.
what a lot of people might ask: well, how much consideration? Well, um, it's good enough to put just $1. You can put one
Yeah.
dollar as valuable consideration. And for years, I had thought, well, how do we know $1? Where do we get that? Well, this book says it right here. It is customary, though not necessary, to mention some nominal sum as one
One
dollar, even when
dollar.
no money price is paid. So
Interesting.
that means that a deed, like if you want to convey property, like if I wanted to convey books to somebody, there's no money, there's no price paid, but I'm putting valuable consideration to move the title, such as $1.
$1. Interesting. That's okay. Yeah. See, I'd never seen that written anywhere either, actually. So, yeah.
The property to be conveyed should be described by boundaries as minutely as possible. The safest way to describe is to copy faithfully the legal description as shown in a certified abstract of title.
Mm, hmm.
The mode and effect of an acknowledgement or of a deed is in most states governed by the law of the state where the land lies and not by that of the place where the acknowledgement is taken. So basically, whatever jurisdiction you're in. The estate passes upon the actual delivery of the deed. If it is retained until the grantor's death, it becomes void and of no effect. But where it is delivered to a third person to transfer to the grantee upon the happening of some event, as the death of the grantor, the estate will pass upon that final delivery. Such a deed is called an escrow. Uh,
Oh.
Recording. The object of the public recording of a deed is not to give validity as between the grantor and grantee, but to protect the grantee against
Mm,
subsequent bona fide purchasers or mortgagees and against the grantor's creditors.
interesting. Okay. Which the grantee, another name for that is the beneficiary, right? That's,
Yeah. So if someone conveys a beneficial interest to you and you record that, let's say that a bunch of creditors are coming after that same person, your beneficial interest is protected because it has been recorded.
hmm. Hmm. Yeah,
See right here.
that's essential right there. That's a really good thing to know.
Deeds should be signed, sealed, witnessed, acknowledged, delivered, and recorded. So, like, let's say, you place something on, or, you convey beneficial interest to somebody. You have to sign it. It's got to have a seal on it. Like if you've got your own private business trust, personal seal, it's got to be witnessed and acknowledged by a notary. It has to be delivered. So if you send it certified mail with a return receipt requested, and then you get your green card back, and then you record it, that deed is as good as gold and it's solid.
Hmm. Interesting. What's it saying down here in the caution part?
Caution, do not purchase real estate without first having the title carefully examined by a competent lawyer or title company under the Torrens land title system in use in some states. Titles are passed upon a qualified examiner, and where found valid, a description of the property is placed on the registration books and a certificate of ownership issued to the party entitled thereto.
Okay. As I don't know anything about the Torrens stuff. I've never looked
I
into
don't,
that. So.
well, it's got to be, there's the Torrens land title system. So it looks to me like in some states, titles are passed by an examiner, so not between people. So I think maybe if the property is in the public, maybe, or
Huh.
I guess if you're moving land or something like that, then you have to have well, this is in 1918. A
Hmm.
qualified examiner has to be the one that passes title.
Interesting. Huh.
So I wonder if it's, I don't know.
Yeah, I don't know.
I don't
I don't know. I know a guy we follow, the private fellow we follow. He talks about the Torrens thing a
Oh,
little bit.
right, really?
Yeah, so he doesn't get into it too far, but he said he lives in a Torrens County when he was going through one of his cases and tried something and it didn't work because it was some rule or something.
Yeah,
Interesting.
so I'm wondering if they're holding the title in a way that any sort of transfer has to go through them. Sounds like.
Yeah, must be. Must be. Huh.
But we got different
Interesting.
types of deeds here. We got a warranty deed, a general warranty, a special warranty, a quick claim deed, a trust deed, a tax deed.
Which a quit claim deed, that's how a lot of people are operating today, right?
Oh yeah, that's I've known people that when they were going through a divorce and both of their names were on the mortgage, one of them did a quick claim deed and left them with all the debt.
Jeez, sorry, I don't mean to laugh, but geez, my goodness. People
That's
are.
you know what? Let me tell you that's one of the best things my father ever taught me. He's like, "Oh, okay, you want the house? You can have it. Here you go." and
Yeah, you can
all
have
the
everything
debt,
that goes
duties,
along with it.
liabilities, and obligations that come with it. See ya.
And wow, what a boss move. Nice.
No, seriously. That's who taught me to make sure you keep all of your receipts and think outside the box a little bit.
Yeah, yeah, right. Yeah. Okay, nice. Interesting. That's funny.
Yeah. So, anyway, but they give different forms of warranty deeds. This indenture, and look how
Indenture
they do the
indeed.
language. Fourth day of March in the year of our Lord,
Yep, that's
1000.
how I write mine on my anything. That's how I write the date.
Yep. That's the species that you write in, which is you
Yep.
write it out in letters, not in numbers.
Hmm.
And so, gives, and the language in here is
And
very
because it
well.
does make a difference, and the reason it makes a difference because if you're, I'm pretty sure if you're writing in numbers, that's basically military stuff, right?
Yeah,
That's
that's
yeah,
all accounting. That's the other side of the, yeah.
yeah.
So then we've got mortgages, and this one is I'm not going to go to this other page because you're going to flip. But a mortgage is a conveyance of property, either real or personal, given to secure payment of a debt or the performance of some special act. When the debt is paid, the mortgage becomes void and of no value.
Huh.
The
Okay.
person mortgaging his property is called the mortgagor, and the person to whom the mortgage is given, the mortgagee. In real estate mortgages, as usually written, the person giving the mortgage retains possession of the property, receives all the rents and other profits, and pays all taxes and other expenses until breach of condition and foreclosure. Must be in writing, must be
Mhm.
acknowledged. The accompanying bond or note. It is usual not only to insert a covenant of promise in the mortgage to pay the debt, but for the mortgagor to give also his bond or note as evidence of indebtedness. So I think that's the promissory note there.
Yeah.
In this case, the mortgagee may sue and recover upon the note or bond, or he can foreclose his mortgage, and if there is not sufficient realized from the sale to pay the debt, he may recover the balance on the bond or note.
Huh.
The bond or note is drawn precisely like any other instrument of the kind. In the case of notes, it is customary to state therein that they are secured by a mortgage of even date.
Ooh.
Redemption.
Here we
By
go.
what is termed equity of redemption, the mortgagor is given further time to redeem his property after the debt for which the mortgage is security falls due. Within this extended time, he must pay the full amount of the mortgage with the interest prescribed by the statute. The equity of redemption.
Aha, here we
The
go,
equity of
buddy.
redemption is such a positive right that it may be sold, and is of such
Whoa.
character that the law refuses to allow it to be foregone, even by an agreement to that effect in the mortgage. So even if in the
Interesting.
mortgage you waive your right to the equity of the redemption, you still don't lose the right of
That's
equity.
crazy, dude. That's
Yes.
a really wow, that's powerful right there.
So
Interesting.
let's see. Mortgages are sometimes so drawn that a single failure in paying the interest at a stated time renders due the whole, both principal and interest, and gives the mortgagee authority to sell the property long before the debt is due. Assignment. A mortgage can be assigned, but unless the bond or note is also assigned, it is worthless and gives no right to foreclose. And such assignment should include also the bond or note and should be acknowledged and recorded.
Hmm.
So anyway, this mortgages is a huge section in here. It also has lots of different forms and templates for different types of mortgages of property, which includes warranties and how to foreclose a mortgage. Um,
Interesting.
Chattel
Yeah.
mortgages, which chattel mortgages is basically pawning.
Oh, okay. Interesting.
Yeah,
Yeah.
so a chattel mortgage is a mortgage on personal property. Persons sometimes desire to use their personal property as security and yet retain possession of it, as for instance, furniture, machinery, tools, library, etc. This can be done by giving a chattel mortgage, which is really a conditional sale of the property to the creditor, whose property it becomes if the debt is not paid when due. A chattel mortgage must be in writing and must be recorded. So
Hmm.
it's actually a little less like pawning and more like, hey, I'm going to put my stuff up as collateral. Like I'll pay you, but if I don't pay you, you can come take my stuff.
Hmm. Interesting.
Yeah, rules governing chattel mortgages. Talking about who's in possession and when. abstract law. And so this is the next section, section 12, abstract of laws relating to deeds. So like for my state here, pretty simple. A deed must be acknowledged and recorded. One witness, no seal required. Husband must join in conveying the real estate of the wife.
Hmm.
Come on. So this is you here, yeah?
Yep. Yep. Deed must be attested by at least two witnesses. A scroll answers for a seal. A scroll, huh? Must be acknowledged and recorded within the county where the land lies. Wife must join to bar dower and may convey her separate estate without her husband joining in the deed. Interesting. That's very interesting because in equity, that's usually not at all how it works.
Yeah. And then it goes through leases and everything else, and that's basically the extent of the book. But where was it? It was literally like in the first freaking couple pages. I want to say it was under promissory notes. I'm trying to find the restricted signatures area where it said it was talking about without recourse, and it said it multiple times that you should write without recourse
It was
near
probably in the
your.
signatures part where they had that, I'd imagine.
See.
Oh,
Hmm.
all right. Well,
Well, yeah. Let me look for this for a second, then.
actually, let's save it for hour two, actually, so you can find it because we're time's up now.
Okay,
So,
we'll do.
yep. Yeah, so that's gonna do it for hour one of the Learning Out Loud podcast. This is episode 8, and that we went through that a little longer than I was expecting. So actually, in the next hour is where we're gonna get into 3 maxims. Equity will not suffer a wrong to be without remedy. Equity imputes an intention to fulfill an obligation, and equity aids the diligent, not those who slumber on their rights. So, if you guys want to get a hold of those, all you have to do is go to truelifeproduction.com or learningoutloudpodcast.system.io and click on the foundations episodes, and that will get you to the full 2 hours, and along with the transcript, show notes, all the extra goodies and stuff. So we hope to see everybody over on the second hour, and never forget to seek truth and honor the creator above all, and let that be the whole of the law.
That's the important thing here, is that everyone's word should be meant for a use.
And the words that I'm using today are meant to pull down idols within people's temples.
Meaning that I want to destroy
Falsities that they have idolized.
for their entire life.
And just pull those out and sweep them clean. And before that temple,
And get reinfested with a new lie. Give it true life.